Good afternoon. My name is Merritt Green. Here with us is Joanna Foard, who leads our family law practice. And thank you for joining us today. We are going to provide, and we've done this webinar once or twice before, an opportunity where Joanna is going to answer questions that she commonly gets from clients. And hopefully it will be helpful for you. And if you have questions, please use the questions tab within the GoToWebinar template. So with that, I'll give a little introduction of General Counsel, and then Joanna hopefully will say hello and provide a little introduction of herself also. But just quickly, General Counsel was formed in 2004. We serve as a legal counsel of businesses, nonprofits, and individuals throughout the DC area and across the country. We are headquartered in McLean, Virginia, so we do represent a lot of individuals and businesses here in the Northern Virginia area. And we have 6 practice areas. So business law, that's everything from contracts to, buying and selling businesses and everything in between. We do labor employment law, large government contracts practice representing government contractors, litigation, dispute resolution, state, federal court, arbitrations, our family law practice, which we're going to talk about today. And then we're also doing estate planning and business succession planning. Joanna, do you want to give a little background for yourself?
Absolutely. Thank you, everyone that's logged in. Merritt, thank you so much for assisting and hosting this with me. I really do enjoy these. This webinar we've put together with the top questions that people ask us, and I exclusively practice family law. Like Merritt said, we're in McLean, so I'm always happy to speak to anyone and answer any questions that you have. There are a couple ooh la la things written here about me, but I really do just love the area of family law, and I just love helping my clients.
And Joanna's being a little humble in that she does have and has won a number of awards. But if you have the chance, you should go to avvo.com, and you can look up her name. And she has over 130 reviews from clients that have worked with her. And if you look around to other attorneys on Avvo, there are very few, if any, who have as many favorable reviews as she has. So if you're thinking about an attorney to work with, that is a great testament to her skills and devotion to her clients. And you don't have to read this, but this is just 2 of the reviews that I took at random. So she does a great job for her clients. So with that.
And I saw on the last slide, we had all the Client's Choice Awards that I've received, and recently I got the 2021 award as well. So,
Yes. All right, with that, let's go ahead and get into the 20 questions. So, number 1, my spouse and I have not been getting along for the past few months, and I feel like we're contemplating taking the next step, but neither one of us has actually made the first move. What are my options, and how do I start the process?
So when people call and talk to me, it's not always clear I want to file for divorce right away. A lot of times people are just asking questions similar to this fact pattern. We're not getting along. What are my options? What can I do? And during a call with me, I'll go through the particular set of circumstances. Oh, and my disclaimer that I always like to say is, this is not intended to be legal advice. Family law and really every area of law is tailored so specifically. So, there are certain things that might sound like it's what you're going through, and, I might provide a response, but maybe with your particular set of facts, the actual legal advice might be different. So this is just merely meant overview, top questions that Merritt and I receive, and, generally some information for you. So, with that,
very good. Nice disclaimer.
Yes, thank you.
I thought you were slipping that. You didn't provide it, but go ahead. All right, what are the options in starting the process?
Yeah, so essentially, one of the first things I would tell someone is that we can't just necessarily file for divorce. In the state of Virginia, there's a requirement, a separation period. And if there are no minor children, the separation period is 6 months. And if there are minor children, it's a 12-month separation period. So, definitely discussing what separation period means and how to get that going would be very important with this particular set of circumstances.
And how you do it, whether you try to do it under the same roof, which I think could be very stressful, but economically might be necessary sometimes, or else you move into different properties, and then if you have a house, which spouse moves out into an apartment, it's a difficult process.
Absolutely.
And something that Joanna and I were talking is just about slightly before we started this was, do you want to consider updating any estate planning documents, during this time period? If you have a will, for your 401k, and your 401k, you designate your spouse currently as the beneficiary, might you want to change that? Because, you always use the example, at least I do in estate planning, you get hit by a bus, because hopefully it's never going to happen to anyone. But if you get hit by a bus during this 12-month separation period, you may not want your $1 million or your $100,000 401k going to someone that you're about to get divorced with, especially if you have a blended family or any other situations going on. So something to always keep in mind. Number 2, I'm in the early stages of a divorce, and I keep hearing about mediation, but I don't know what mediation is. What is it? Do I have to do it? Who pays for it?
So mediation is a great tool. Depending on your case, it might, save a lot of attorney's fees, save a lot of time. And mediation is when you and the opposing party attend with a neutral third party serving as a mediator. If you have an attorney, your attorney is there with you. If the opposing party has an attorney, they also attend. And the mediator is there. They're not there for one side or the other side. They're just someone that is well versed in the law, specifically family law in my situation, and they help to facilitate some type of trying to reach a resolution. And a lot of times I tell people I like to go to mediation, maybe not necessarily to resolve all issues, but narrow them, because if we're able to chip away at all the things, especially if you have minor children, working at General Counsel, I have a lot of clients that own businesses or are married to someone that owns a business. And, maybe we can determine distribution of business asset, but, keep the custody for a trial or something like that. Just using mediation as a tool to either get rid of all of our pending matters or chip away at them.
Now, is mediation required, or is it something you can optionally do?
So some states require mediation prior to going to trial or court. Virginia is not one of those states. So mediation is totally a voluntary process. If someone does want to attend a mediation, but the other party doesn't want to, you could always file a motion and request that and ask the judge to require you to attend a mediation.
And who generally will pay for it?
So it depends. Sometimes the mediator's fee will be evenly divided. If one party makes substantially more than the other party or has a lot more assets, sometimes they'll pay 100%, maybe 75%. I've seen it all.
All right. Question number 3. Child support and spousal support was set 3 years ago. Since then, I know my ex has earned a promotion, but he or she is refusing to provide me with more support. What can I do?
So child support and spousal support have different requirements when you're trying to amend them. And I'll start with spousal support. So essentially, when it comes to spousal support, there are ways that you can set it and it is absolutely not modifiable whatsoever. So some of those ways include specifically in an agreement, either in a mediation setting, as we just talked about, or just going back and forth with the other party about the terms that we're going to agree to. If we agree to a spousal support number, the amount and duration, and we put that it's non-modifiable, that holds true. The case law in Virginia is clear. The judges, if it says non-modifiable, it doesn't really matter at all, the other circumstances. But child support, on the other hand, is always modifiable while the child is eligible to receive that support. So essentially, saying that X has earned a promotion. So what we would do is look at when the spousal support was set, look at the particular language and see if we have any wiggle room as far as filing a motion to amend that spousal support. Now with child support, what we could do is file a request to amend the child support based on the promotion, if the promotion would in fact change that amount, pretty substantially. And at that point, we would enter into what's called discovery, and we would request just the documentation to demonstrate how much more they are earning with this new promotion. Because it's one thing for someone to testify, I'm earning this amount, but as lawyers, we need to see the amount. Even non-lawyers, you can't just go based upon, okay, I trust what you're saying. No, we never trust what they're saying. We need to see the documentation, and we can go from there.
You want to trust but verify? You can subpoena the employer.
Oh yeah, we can have lots of fun getting the information one way or another.
So within a marital separation agreement, we haven't really talked about marital separation agreements yet. We know how much you love them and how you think that they should be very thorough and detailed. Do you generally recommend having modifiable or non-modifiable spousal support?
Depends if I'm representing payor or payee. If my client's receiving, maybe we could talk about, is this a very young individual that has multiple business interests that it looks like are going to be skyrocketing? Are they, a doctor very early on in their career, an attorney, someone that's going to be earning more, that we potentially could, those kinds of things. We'll brainstorm whoever I'm representing.
Gotcha. All right, let's go to question number 4. I'm the sole breadwinner in the relationship and my spouse doesn't work. I'm worried that they'll be seeking a ton of alimony and that I'll just be working hard to pay their bills. Can I quit my job or go work at a lesser paying job to avoid paying so much in spousal support?
And you'd think that this question, this is a made up question. No, this made the top 20 list for a reason. I have been asked this over my career many, many times. And the answer is don't do it. Usually I'm getting the phone call before they've quit the job. Essentially what happens in the state of Virginia is that if an individual quits or leaves their job and either is unemployed totally or underemployed, earning substantially less in an effort to try to pay less in spousal support, even though that individual is either unemployed or earning substantially less, the court has the right to impute that person back up to the highest salary that they were earning before leaving that position.
So you can't try to sabotage your career, just to be vindictive and stop paying spousal support. Or child support, I guess.
Yes.
Is that applicable? So where here the question is about spousal support, would it be the same for child support?
Yes, it would. The court also has the ability to impute for child support purposes too.
That would be difficult. All right. Question number 5. I want my child to continue doing virtual learning. So this was, obviously we're in pandemic mode. And my ex wants the child physically to go to school, even though we still have the option for virtual learning. What are my options?
So even though we're not seeing this as much, since, people are either doing some type of hybrid model or a lot of children are back in school, you do still see this. And, the main thing that I think that this question represents is that in family law, there are really not many bright line rules. There are not usually like black and white, yes or no responses. And, the facts and circumstances regarding the health of the minor child, and the parents or any other family members, elderly, young children, people with any illnesses, or, that if someone contracted coronavirus, things like that. And even with all of that information, even if you think you have a slam dunk case, there's no way a judge could send this child in person based upon these facts and circumstances, you never know what a judge will do. And I think that this question is a great thing to remember, that, when you go to court, the answer and, the outcome is solely up to the judge. So it's something to consider before going forward to court. And some people want to, it's the principle, or, they feel very strongly about it, but you never know what a judge will do.
I think that's part of what makes family law so interesting, is perhaps you have, the overriding standard is the best interest of the child. But then what is the best interest of the child is going to depend on so many different factors, looking at mom, looking at dad, looking at grandparents, looking at where they live. You know, it's probably what also makes it so difficult lots of times.
Absolutely. And best interest, is it best for a child to be learning at home and not have those connections with other children in that playtime? Or is it best to keep them safe and at home and not exposed? So even best interest, as you're saying, Merritt, it's difficult to figure out what a judge would do.
Yep. All right. Question number 6. I quit my job 3 years ago when I had my first child and have been a stay-at-home parent since then, with no income for that period of time. My wealthy spouse has now filed for divorce, but I have no money for an attorney. Is there any way I can have my ex contribute or totally pay for our attorney's fees, for my attorney's fees? And if the spouse shuts down our joint bank accounts and threatens to stop paying for the mortgage, the car payments, money for groceries, etc., what can I do?
So there is a type of motion that you can file before a court has determined if a spousal support or alimony award is appropriate in just like a temporary during the term of the litigation before a final order is entered. And it's called pendente light or pendente lite, some people say. And essentially what that does is either the two parties, the spouses or through their attorneys, can determine an amount that would, maybe cover the mortgage, maybe this individual doesn't have a job and the home is a marital home, maybe the largest asset, and the other party has the ability to cover the mortgage, preserve that asset before, the distribution of assets and liabilities are determined. And, a court can determine until final order or for a specific period of time, the amount. So that could be attorney's fees in this case, or, some type of spousal support on a temporary basis.
What always astounds me when we talk about this, though, is the court needs to have jurisdiction of the matter to have pendente lights. So as you said earlier, in Virginia, and I imagine some other states also, but in Virginia, you need to have a separation period, 6 months without children, 12 months with children. So in that circumstance, if the wealthy spouse, and they have 3 kids, the wealthy spouse cuts off the other spouse, no money for groceries, stops paying on the car, what does the stay-at-home spouse do in that circumstance? You have 12 months of separation. You can't get pendente light, because the court doesn't have jurisdiction until you file for divorce, which you can't do until after the 12 months. What do you do in that circumstance?
I think the best thing to do is to have things well documented in writing. So, saying in writing, either the person individually or through their attorney, I am unable to, pay the mortgage or afford an attorney. I am requesting either safety amount or, a contribution. Please provide that, so that when you do end up in court, you can demonstrate to the court all of the efforts that were made. And, unfortunately, a lot of times people don't want to work with you and you do end up in court. But as an attorney, having that physical documentation to attach rather than someone's testimony, just, oh, I tried to talk to them, they wouldn't talk to me, versus judge, on this day, this day, this day, this day, as we've attached to our motion, my client made reasonable efforts to try to resolve this and provided nothing. So making yourself look like the reasonable individual and demonstrating the other person not being reasonable really is the only true thing that you can do, unfortunately.
So you really can't force them to give you money during that 12 months necessarily, but you could make that person look horrible to the judge. So it's more likely that you'll get more spousal support, child support, custody, and the like.
Yes,
what about for the child? What if that spouse stops providing money for groceries and other care for their children?
Unfortunately, it's a similar thing.
Mm-hmm. Okay. All right, we'll have to think that one through. All right, number 7. Well, hopefully we never see that also. I believe my spouse is cheating. Does it matter when it comes to filing for a divorce?
So when you're filing for divorce, the grounds in the state of Virginia, there are a few different grounds that you can cite, and adultery is one. But as they say in this field, adultery is the easiest to claim but most difficult to prove. It's pretty uncomfortable because the standard that you have to meet is clear and convincing. So it's
So
very
what does
difficult.
that mean? Is that a photograph of them going into a hotel room together and then date stamp photograph of them coming out 2 hours later? Or do you need to have more detail than that?
And the definition of adultery and that, to state those grounds is that the relationship has to be a sexual relationship. So it's pretty difficult, even with the photographs, with the date stamps, you still have to put those pieces together, so to speak. It's
They
not
could have been playing backgammon together.
what they do is what when I'm representing the hotel cover. But no, it really is. It's difficult. It becomes very expensive. Trying to prove it. A lot of times that's when you end up in depositions and you have third parties that you're asking questions, and it can prolong things. But, there are reasons that you might want to do that.
What would be the benefit of proving adultery?
So spousal support, if someone might be eligible to receive it, but is found to have committed adultery, will no longer be entitled to it.
So in a situation where one spouse has, millions and millions of dollars, and perhaps the other one hasn't been working, and the spouse that's not been working has a relationship with the pool boy or girl, just to throw out all the cliches, and they don't get spousal support, that could be worth millions of dollars.
Better hire that private investigator.
I think in that circumstance you might, and work with legal counsel through the process. All right, question number 8. My boyfriend and I have been living together for the last 15 years. We have joint bank accounts. We bought a house together. And when we bought the house, since I had bad credit, we put it in his name alone. The mortgage is also in his sole name. I've stopped working. I've been taking care of our minor child that we share together. We've never been married and are not currently married. Will I qualify for spousal support? What about joint property?
So in the state of Virginia, unfortunately, the family courts, you can't file for divorce if you were never legally married. And even though these parties have been living together for 15 years, unfortunately, if they never actually got married, the woman in this, or whoever it is not able to actually file for divorce. Now, there might be some type of civil action, if she's contributed to things, if you have your bank history or something like that demonstrating the contributions, but that would be more of a civil action rather than the family courts and domestic relations. Spousal support would not be on the table. That's not an appropriate type of relief, unfortunately. Now, if there are minor children as listed here, child support would be on the table. You don't have to be married to be entitled to receive child support. But as far as spousal support, you have to have been married.
So no common law marriage in Virginia. So even if they were out and holding themselves out and husband and wife, and all the teachers at the minor child's school thought they were husband and wife, and they even called themselves Mr. and Mrs. Brown, if they weren't legally married, tough luck.
Tough luck, unfortunately, or fortunately, depending on which.
I guess it's depending on who's your client.
Yes.
So, but a warning nonetheless. So you can't get divorced if you're not married and you don't have certain of those legal protections. All right. And that has a number of other, just really quickly, a number of other ramifications. I mean, if you think about estate planning and wills, if you're not married, you don't have some of those rights that you'd have for a spouse. So for intestate succession, what happens if you die without a will, or things along those lines. So something else to think about. All right.
And that's why I'm glad that the firm has brought in an estate planning attorney, because like you're saying, so often I'm suggesting to people during the process, once the process is completed, to look into. Most people don't have estate planning documents. So to go off of that, it's really nice for me to have an attorney that I can recommend within the same firm to assist my client.
Absolutely. All right. Question number 9. My husband and I have been divorced for the last 3 years. He has a job with a large government contractor and has been offered a great job in San Diego, which would nearly double his annual income. We live here and we're divorced here in Fairfax County. He's remarried. I'm not remarried. I do not want him to move with our child. Is there anything I can do to stop him from moving?
So what you would need to do is file with the court and state your objection so that you would be entitled to have a hearing and before he moves. And essentially the things that you're going to want to cite are the reasons why it's in the best interest of the child to remain here. A lot of times that includes the family members of the minor child. Are all the family members located here in Fairfax County? How old is the child? Are they very active in the community? Are they involved in lots of sports and extracurricular activities? Would they be, ripped out of those things, everything that they know? Things like that.
You said that if you didn't want the spouse to take the child and move to San Diego, you would file something. Wouldn't the one spouse that wants to move to San Diego need to file something to move and take the child out of the jurisdiction?
Yes, so it would be initiated by the party that wants to move. And then the objecting party has this particular amount of time to file their objection. And that's
so it can just move and, okay. Because the court then, I guess, still has jurisdiction, gotcha.
Yes, and that's when you could get a sheriff involved, an emergency pickup order, and a child would be returned here. And that's the type of case you don't want to be the person that moved with the child without the court's permission.
No, absolutely not. And just not to mention how difficult it would be for the child in that circumstance. All right, question number 10. My 12-year-old daughter has indicated that she doesn't want to stay with her father this summer, or even on his assigned time. No signs of abuse, just 12-year-old has said that they want to be with you. What do you do in that circumstance?
So similar to what we discussed previously, in family law, having that black and white printable written documentation really, really helps, because a lot of times what we encounter is you have one party saying one scenario and the other party saying the opposite scenario. So, the judge determining credibility, meaning who do they believe more, a lot of times can go into it. But if you have factual documentation to support your claim, that would help. So, you always want to be supportive and encourage your children to exercise the time with the other parent when it's their assigned time. But it's a tough situation. So
in that circumstance, though, the 12-year-old daughter says, hey, I don't want to go spend time with dad. And dad says, tough luck, by court order, because most times the marital separation agreement will be incorporated within a court order, she has to. What should you do as the other spouse, the mom in this scenario? You need to encourage the child and say, you really should go. You have an obligation to go.
Yes, absolutely. Encouraging the child to go, but if you have the facts and circumstances to support filing a motion during the pendency, you do want to demonstrate to the court that you're not in contempt, meaning you're not just withholding the child, because not following a court order can hold you're in contempt of court because you're not following that order. So making your best efforts to encourage the child, maybe having a witness there with you, watching what's happening, a neutral somewhat, so that they could also testify.
And documenting it with your legal counsel, and talking through it with your legal counsel, because again, I think you're right. You could have a show order cause being held in contempt. If you are actively in any manner, perhaps encouraging the child not to go see dad. All right, question number 11. And as a reminder, if anyone has questions, please go ahead and put them out. Question number 11. We got divorced 4 years ago where the kids were in kindergarten. Now they're in sports, summer camps, orthodontist appointments, etc. Our MSA, our marital separation agreement, doesn't deal with these issues, and my ex and I cannot agree on anything. What do we do besides go back and get angry at the attorney you used?
Yeah, I mean, unfortunately, a lot of times I'll see these marital settlement agreements that will be 4 pages and you have children involved. And I'm like, Merritt and I joke, mine are like triple, sometimes quadruple in length because I tried to make it so unambiguous that anyone at any time could pick this up and know exactly what the intention of was the parties. Because, you'll be chatting and say, oh yeah, let's just split it equally, or, oh, I'm earning twice as much as you, so let me do, some type of division. And people think, you're getting along now, you don't need to include it. Even if you're the best of friends and you're divorcing, you have to put specific terms within your agreement, period. There is no reason not to. The best agreement would be one that you guys sign, put in a drawer, never look at again, work together and figure it out along the way. But unfortunately, there are bumps and, people start dating new people, introducing new people, feelings get involved. And, if you don't have the documentation to back it up, you're out of luck. So in this situation, you can't really hold someone to be 50% responsible for certain summer camps, sports, things like that, if it's not documented. So you again would have to reopen the case, hire an attorney, file a motion to establish these things when it really should be done the first time around.
Well, and a judge might not, order someone to pay for a summer camp, or the judge may not say, you need to help with, sports camps or after school activities. Orthodontist appointment, maybe medical care, would be something there. But it's why it's so important to do it during the divorce process. And I thought you said your agreements are 50 or 60 pages.
They're long, very long.
And it's better to be thorough in that regard.
Like we were talking about yesterday, when there's a sale of a house, you can't just say, we'll sell the house. How long are we doing that? Are repairs needed? And who's the realtor going to be? And what if we don't agree on the sale price? And is one party living there? Like, this is one topic of a list. So you really have to be detailed.
Yep. And part of what Joanna is talking about right now is we're actually doing another webinar just for realtors in the next week and a half, talking about all the issues that come up either when someone passes away or in divorce, and dealing with residences and real estate. So, all right, question number 12. My fiance proposed to me last week, and this week I was provided a prenuptial agreement. I'm hurt and confused. What should I do?
Well, don't be hurt and don't be confused, because prenuptial agreements are much more common than they used to be. And, it doesn't matter the age of these individuals or the assets that they have. It's just a lot of people like to keep things separate. I mean, you look at how people, looking at how individuals keep their finances, back in the day, everything, you'd see a lot of accounts, this is our joint account, everybody's earnings go in there, and this is just the money of our marriage, where a lot of times now things are kept completely separate. You've got one spouse Venmoing, 50% of some expense to the other spouse for the separate account. So, maybe that's the way that you guys are comfortable, and, and you just want to make sure that your wishes are what are followed if you do end up in a divorce situation, rather than Virginia law. Because without a prenuptial agreement, if you file for divorce later on down the line, Virginia law is what is followed, period. If you don't have a prenuptial agreement that's fully executed to attach. So if you both agree to maybe how a certain property would be divided, or if one party owns a business, things like that, you can address them in a prenuptial agreement. And if you ever file for divorce, that particular issue or those issues listed in the premarital agreement would rule. And so long as the prenuptial agreement is deemed valid, which is something important to note, but so long as it's deemed valid, then those topics can be addressed in that way.
But still, it is, lots of times you talk, and prenups are a difficult topic. And we've dealt with situations where we've had clients who have either given a prenup to, a fiance or received it, and it's hard on both sides. And it does hurt some folks sometimes. And because you don't want to think that, oh, we're not even married and planning for divorce. And I guess you just have to think about it analytically and, as you said, but it is difficult. All right, well, let's see here.
Don't sign anything before you talk to a lawyer. We'll plug
Yeah,
that.
absolutely. All right, we have a question here. Is there something you should file to start the 12-month separation period? Is there an official first step? I've heard you can remain in the same house, and if you can prove that you have not been intimate and can demonstrate you haven't acted as a regular married couple, you can count that time towards separation. So there are a few questions there. Do you want me to break it into pieces?
I think I can go. Let me know if I'm forgetting something. So essentially, there is in the Virginia code that you follow, there's like a list of things that qualify. There is no document that you file that begins a separation period. But there are things, it lists things like, are you cooking meals for one another? Are you doing each other's laundry? Are you sleeping in the same room? There are things like that. So so long as you qualify under those things, essentially that's when the separation period begins. And a lot of times what I will file will also be an affidavit of someone that knows both parties that essentially swears and affirms that the date that the parties are saying that separation began is in fact true.
Is there sometimes a dispute over that date?
Yes, there is.
Okay, so you probably want to work with your legal counsel, to sort of make sure it's done right, and if you're going to stay in the same house, maybe you move to the basement. I'm not even sure you'd want to be in the same floor or, sharing the same bathroom. Not only for, making sure that the separation is properly done, but it's just a difficult time going through that separation, especially if there are kids there.
Absolutely. And you want it to be as clear as possible. So again, we go back to the documentary evidence. So maybe, just either emailing your attorney or emailing or texting your spouse and keeping a copy of that, saying, okay, as of this date, I have, moved into the basement, or I'm going to be staying with so-and-so. Sometimes we do have a rental agreement, a lease that we can clearly demonstrate, when it started. But with the pandemic, a lot of people have just remained in the same house.
Now, we haven't talked about this question. You're never supposed to do this, but let's say one of them is living in the basement, the other one stayed upstairs, and they were both on their own floors and had a little extra to drink one night, and one thing led to another, and they had some intimacy. Mm-hmm. Does that reset the clock, or as long as they're remaining separate in other ways, is that slip up, does that not reset the clock?
So essentially, if you follow the code strictly, the clock has reset. However, oftentimes, I don't want to say 10 times out of 10, but maybe 9 times out of 10, even if something like that happens, the parties don't want to restart the clock. It's even more painful than it was before the clock started originally. And, they just both decide, let's just not dispute it. Because so long as the parties aren't disputing when the date is, you're able to put the first date.
Mm-hmm. Interesting. All right. Well, and what if they were disputing? Would a judge, most of the time say, you slipped up, sorry, that restarts the clock?
I mean, unfortunately, one of the terms listed specifically indicates, that they're not intimate. So I would say that a judge probably would say that the clock restarts.
That's interesting. So either something you have to be very careful about, or you could use to your advantage, depending on what you're trying to do. All right. There was another question asking for the actual code. I don't want to put Joanna on the spot asking if she knows the actual code section. So that person, you could send an email to Joanna. I'm sure she'd be happy to follow up with you.
Absolutely.
Question number 13, although I wouldn't be surprised if Joanna actually knows the concept, but let's not go there now. Question number 13. My spouse bought me a very expensive new car a few months ago and has now just filed for divorce. Do I get to keep the car?
Well, so Virginia follows equitable distribution. So what we do in the state of Virginia is we would make a list of all of the assets and all of the liabilities of the marriage. And essentially, it doesn't have to equal to the penny that each party is receiving the exact same amount of the assets and liabilities. But, if this is deemed a marital asset rather than a gift, interspousal gift, then we can look at the other assets and maybe determine based upon the value of the vehicle, if it is deemed to be a marital asset and that person wants to keep it. Maybe there are other assets that aren't as important. Maybe there's supposed to be a division of a 401k or something that we can do a little bit less or more, so that party can be guaranteed to keep that vehicle.
Now, what if it was a gift? What if it was given on Christmas Day and came with a red bow like you see in all the commercials?
Depends if my client was the one receiving it or giving it, but typically it would be deemed a gift that the party would be able to keep.
And then so gifts are excluded from marital estate for equitable distribution purposes?
Typically, not always. So there are other things to be considered, but typically I think that you would have a strong argument to demonstrate that it was a gift.
So if during a 30-year relationship or 10-year relationship, spouse has been given, jewelry every year on Valentine's Day, or Christmas or on anniversaries, would those all be excluded from the equitable distribution potentially?
Potentially, yes. I think that you would have a strong argument that the person that received them should be able to keep them.
Interesting. All right, question number 14. We have about 18 minutes to go, so I think we're doing well. Currently married and had a family member pass away recently. I know that I'll be entitled to inheritance, and I don't want my spouse to receive any portion of it. How can I protect my money?
So this is a great question, and I'm sorry for your loss to this individual. But essentially, what you can do is, I always tell people, if you have funds like this, don't mix them with marital monies. So don't just plop, X amount. Let's say it's $10,000. You don't just want to deposit that right into the joint bank account, because things could get a little bit confusing. So, and there would also be an argument that you've made a non-marital asset a marital asset, and that it would be, need to be divided equally. So essentially what I tell people is that putting it into a separate account totally, so that there is no confusion and it just remains a non-marital asset. If the other party does want to file a motion and ask for it to be deemed a marital asset, you can demonstrate that there was no commingling, and it can be easily tracked.
What if you use that money to renovate the bathroom in your house?
That almost always is then deemed to be commingled and a non-marital asset turned into a marital asset if the home is marital property.
Okay, so that's difficult. So you really do have to keep it absolutely separate.
Yes.
All right, question number 15. I'm currently divorced. My ex is required to pay a certain percentage of uncovered medical, dental, and extracurricular activities for our minor child, but's refusing to pay. What can I do?
So in this situation, if you do have that order that ratified either your marital settlement agreement, or if you went to trial, the trial order that basically indicates the division of the uncovered medical, dental, and extracurricular, if the party is refusing to pay, again, you want to have those emails or other written documentation demonstrating that you have, in good faith, attempted to resolve the matter. There's not a requirement for that, but judges, they like that, to see that you did try to resolve it, because these judges have so many cases. And, if it's clear that one party owes the funds and still you're making the effort to try to resolve it without, judicial intervention, it always helps. So I would say get maybe 2 or 3 emails, something like that, saying, I'd like to be paid these money. I owe these monies that you owe, cite the, paragraph in your agreement, write the amount of money that you want, put a deadline on it. You know, don't just say I'd like to be reimbursed, because that could be never, you know. So maybe just say, you know, 30 days, 15 days, whatever you want to write. And that usually holds a lot of weight.
And then potentially even have your attorney send a letter, especially if your spouse has an attorney also. And oftentimes in Virginia, you have the obligation to, as an attorney, to try to resolve something before filing a motion.
Absolutely, that's a great point. And also, you could request that your attorney's fees, should you incur attorney's fees, retain someone to prepare and send a letter for you, or represent you at that hearing, you could request that those be paid back to you.
Excellent. All right, I've been married for 50 years and have been working for my entire marriage. I have a significant retirement account and want to know what's going to happen if I get divorced.
So retirement accounts in the state of Virginia are, while you're married, that is deemed marital property. So unfortunately, I mean, 50 years, come on, you can't be that mad that you have to, you know, divide it. You guys have been together, but that is something to consider, that you know, if you are thinking about divorce and it's, you know, not been that long, your retirement continues to build, that's additional funds that are going to be, you know, split.
And what is the special term? I forget it now, where you can do a valuation of a 401k or retirement monies. So if he needs to split it in half, it can be done in a tax advantage manner.
Absolutely. So it's QDRO, Quadro, and there's a document that can be prepared that essentially makes it a non-taxable event to remove whatever portion it is from the person who collected the retirement and place it in a similar account of the other party. Now we can make that a non-taxable event, but if and when the funds are removed, or some of the funds are removed by the recipient, you need to talk to someone, and Merit has some great contacts that I've used in the past if anybody needs some names of individuals that can, you know, tell you different ages that you want to wait, amounts, things like that. So that's something to be considered.
Excellent. All right, thank you. Question number 17. I haven't been served with the divorce papers yet, but I know they're coming. We share children together, and I truly believe the kids should spend more time with me. I know this is going to be a custody battle, and I'm guessing things are going to get ugly. What are some of the things the court looks at in determining custody so that I can start preparing?
So again, you know, a lot of family law turns into he said, she said. So any documentation that we can have, any witnesses that you can start thinking of, you know, those types of things, and just trying to work together. I know it's difficult to co-parent, especially if a relationship is deteriorating, but you know, if they're texting you, you know, expletives, not responding with expletives and screenshotting that and sending it to your lawyer to demonstrate that you're trying to keep a cool head, you know, those types of things really do go a long way.
So really either keeping a diary or sending emails to yourself, so you're keeping all of those contemporaneous records, so you can have them as evidence if need be.
Absolutely. And I do tell people, if you have, you're co-parenting with someone that's often late or missing their time, or, you know, needing flexibility, not following the plan, just keep a journal at or near the time that occurs, so that if, you know, I have a pretty great memory, but if someone asked me specifically at 3 p.m., you know, 2 months ago, you can't remember everything. So having that journal, like Merritt said, that you can reference if you're in court, really helps.
Absolutely. All right, question number 17. I'm sorry, number 18. My spouse is really sneaky and untrustworthy. Sorry to hear that. And I just know he or she is hiding assets. I never had access to the financial information during our marriage. I'm afraid they aren't going to give up all the financial documentation, and I won't receive my fair share. What can be done?
Now,
this is where Joanna starts smiling and feels giddy about all of the discovery that she gets to do.
I mean, my joke is I will depose your grandma, you know, like whatever we need to do to get financial information for my client. Third party subpoenas, your business partner, your girlfriend, your high school girlfriend. I will talk to anybody. I will, do requests for admissions, interrogatories, requests for production, depositions, whatever we need to do to get that full financial picture to protect my client, we're going for it. So this, I'm sorry they're sneaky, but good for you for recognizing that. And, let's go get the information we need.
And through the court system, we have the ability to track the money, to go to bank accounts, to talk to the employer, to look at investment accounts, to ask questions, even if it's the grandma. So it's something that can be done and that we have experience with. All right, question number 19 is, we've been divorced for 3 years. My ex is remarried and their new spouse is very successful, makes tons of money. They've moved into a fancy new house. They have fancy new cars. And my former spouse is refusing to pay additional child support or spousal support than was previously ordered. Do they have to? What should I do?
So this is a tough question because essentially the courts are supposed to be looking at the incomes of the parties. So even if one party does marry someone that's very wealthy, absent that new wealthy spouse making in-kind payments toward things for that ex-spouse, there, how we talked about before, the imputation of income, if someone has a high-paying job and either completely quits it or gets a lesser paying job, it's not like that in this situation, unfortunately.
So, and it's interesting, so you have non-modifiable spousal support. Here's a circumstance where, 5 years ago, one spouse wasn't working and you were representing the working spouse, and you might want that spouse support to be non-modifiable. But then what happens if the other spouse then gets remarried to a quadrillionaire, and you have to keep paying that, $10,000 a month spousal support? You might not be very happy about that. So it's interesting in that regard. And I guess child support, in that circumstance, it depends. And I guess what we've also looked at recently, or when we talked about, is if the one spouse used to have to pay rent or mortgage and groceries, and they don't have to do any of that, that income can be imputed to them, to perhaps be used to modify the child support.
Absolutely. And when I talk about the in-kind payments, that's exactly what I mean. The mortgage, the rent, the groceries, things like that.
Gotcha. All right. And question number 20, and we're sort of right on time with even a minute or two to spare. I'm going through a divorce and my spouse and I purchased a gorgeous piece of artwork on a trip during the marriage. We both want to keep it. I know this is going to be a battle until the end. Help.
So this is similar-ish to the vehicle that we were talking about that was a gift, but now we have that the parties jointly purchase something. So you have something that will likely be deemed marital property. And again, how we were talking about the equitable distribution, what we would do is make a list of all the assets and liabilities. And if there are other assets or liabilities that we can use to offset, maybe you might be able to keep it. But if you both want to keep it, unfortunately, I've seen judges tell them, neither one of you get it, just sell it and split the proceeds. So the judges really don't have a lot of creative ways to try to resolve it if it's a marital asset and both parties want it. So doing your best to, if it's a piece of artwork that you really, really, really want to keep and it's absolutely, you can't replace it, then maybe, getting an appraisal, the other party getting a competing appraisal, maybe if they wanted to, determining the cash value, maybe offering a little bit more just to be able to keep it, might be an option.
Yeah. But that's difficult. What if it doesn't have real monetary value? It's more sentimental value and both parties want it. I could imagine you get to a situation where you flip a coin. What about the family pet? You're married, you get a dog together, and you both just absolutely love that dog. You have 2 kids and both kids love the dog, and the kids are going to want to spend more time wherever the dog is. So both mom and dad want the dog. How do you resolve
I've
that?
litigated with about animals before. I literally have. So it, could be like a custody type of thing, week on, week off, or, something like that. That you can't sell. And I mean, I guess you could, but typically, you're just going to either one party will get to receive the animal, or you do have to enter into some type of agreement with sharing the pet.
Or do you do, best interest of the animal, which is, does one spouse work and the other not work? One has a yard, the other lives in a condominium. Yeah, and that's part of, I think, what makes divorce law so difficult sometimes, or going through divorces, is the emotions connected to the family dog or a piece of artwork, or, time with your children. They're difficult issues, which is, again, why I think, General Counsel is so lucky to have Joanna here. And as you read the reviews from her clients, she really cares about what she's doing and helping her clients through the process. So with that, I think we've answered some of the questions, and we have this. So Joanna, any sort of final thoughts?
These were just like top 20 questions that I've seen a lot. Of course, there are many, many other topics. If anybody has any questions, please feel free to either, email me directly, or, contact the firm, get in contact with me. I'm happy to chat. I'm also happy to provide a complimentary 30-minute phone call with anyone that attended this webinar to go over anything. If you heard something and you have more specific questions about what you're going through, I'm happy to talk to you. It's confidential. I'm happy to answer any questions that you might have.
Wonderful. Well, Joanna, thank you so much, and hope everyone enjoyed the webinar today. Please follow up if you have any questions. And with that, we're going to sign off. So
Thank you.
Take care.